Hi, my name is Jay Young. I'm one of the owners of Real Property Associates. We're a property management company serving Seattle, Everett, Bellevue, and all of the cities and neighborhoods in between. We have been in business for 25 years and feel uniquely qualified to our claim of having Seattle's best property managers. Today's discussion is going to be about the steps which are necessary to perform a residential eviction in the state of Washington. I am joined by Brian Reed with Brian Reed Law Firm. Brian has been working with RPA for several years and is an expert in landlord-tenant laws. So Brian, let's discuss the first steps of the eviction process, assuming the tenant has failed to pay the rent.
Sure, absolutely. Well, thanks for having me here, Jay. The first step the landlord has to do is to serve a pay or vacate notice. In Washington, it's a 3-day notice to pay or vacate. Sometimes leases might allow for more time, but typically it's 3 days. The landlord has to make sure that that notice is not only content-wise correct, but is also properly served.
And so now we've served the notice, 3 days has lapsed, and the tenant has not paid the rent, and he's not vacated.
Right.
So now what do we do?
Well, the only way to advance the lawsuit forward, we have to bring a lawsuit to advance the matter forward. So an eviction lawsuit is very specific. It's quite different from other types of lawsuits. There's a specific summons. It's an actual form that you have to use. If you don't, it's invalid. And there's a complaint, which would set forth the facts of the eviction. Those documents would have to be served by a process server. The landlord cannot serve their own lawsuit at that point on the tenant.
Okay. And what happens once that's been served?
Sure. So a few things would happen. Ideally, the tenant simply moves out.
Okay.
More often than not, though, they'll respond. They'll ask to do some sort of a payment arrangement or maybe some more time to move. You might be able to work out an agreement, which I call a stipulation, with the tenant that would be enforceable by the court if they don't follow whatever the agreement was. Sometimes tenants don't respond at all and they don't move, and you can enter a default judgment with the court. Other times they respond, it's not possible to settle the case, or both sides aren't interested in settlement. You then would schedule a court hearing after the tenant responds, and you'll get about a 5 to 10 minute hearing in the Superior Court. And the only issue at that hearing is who has the right of possession. Typically, the landlord wins that, certainly if they've done the lawsuit right. And then incidental to that, they might also be able to get a judgment for any rent that is owed.
Okay. So you win at the hearing, and then the next and final process is to schedule the eviction.
Yes. You then give the paperwork to the sheriff. They'll be out often the day after the court hearing to serve the paperwork on the defendant, the tenant. It's called a writ of restitution. The writ gives 3 business days for the tenant to vacate, and if they don't move out within those 3 days, then the landlord and the sheriff can schedule a physical eviction date. The landlord only has about an hour. Bring a crew of movers, your plastic trash bags. The sheriff won't give much time, and he or she will say, put everything out on the street or on the sidewalk, the nearest public property. You may have an obligation to store the tenant's property if the tenant requests that. Doesn't happen often, but just be prepared for that.
Okay. That is the eviction process in a nutshell in the state of Washington. Thank you, Brian, for your time. If you are an owner and are performing management yourself and are faced with a non-paying tenant, we hope that you find this information useful. As always, if you need assistance with property management and or legal work, RPA and Brian Reed are here to help.